All right, students, we're going to get right in here with chapter 15. This is going to be contracts and writing, which are covered under the statute of frauds. There are certain requirements for a contract that um, has over a certain monetary amount or contains certain items that will need to be a written instrument. So it'll have to be a written out contract with the terms stipulated. So it's going to be an express contract. A contract in writing is an express contract. So it's one that all the particulars are out there where you can see them. Everyone is aware of what goes into the contract, all the parties. There's not any guesswork involved with it. So we're going to get into it. This one will not be as long as the one covering the last three chapters. So we'll go through this one, and hopefully by the time you've watched both videos, you can understand this one better based upon the information in the last one. Some of this will be really new stuff. Talking about parole evidence, statute of frauds, because it's not something we went over in the last video. So make sure that you're paying attention. Take some good notes for this to help you with studying for the quiz and with the exams. All right. Under the statute of frauds, and there's a link to Cornell University's law journal or their law library that will help you with this. It'll give you a link to the UCC or the Uniform Commercial Code. You will want to look for the statute of frauds in that. And it is a rule that covers contracts in states that have adopted the UCC. Almost all states have adopted the UCC in some form. Florida is an adopter of it, and our statutes involving contracts and the sale of goods and our version of the statute of frauds is built on the framework of the UCC. So the UCC in itself is not law. The Uniform Commercial Code is not law, but it is a framework for how laws are built. So when we're looking at what goes into the statute of frauds and how it's designed, it is fairly universal in its parameters. So there's not a reason to really break it down much by state. So I'm going to speak in generalities with it and not try to just hone it into Florida. All right. Electronic records are given full effect with it, and its signatures count. Now more and more we sign everything with electronic signatures. When you can send a PDF through Adobe from yourself to someone for a signature, they can set up an e-signature for it. If you take out a loan or take a withdrawal from certain accounts you may have, they may want you to also do a e-signature on an e-document that allows it to be an official signature for you that's tied to you and you only, and may have PIN numbers or things along those lines. Suretyship provisions in this apply to the promises to pay the debts of others. The original promise is a promisor. It must be secondary, not primary liable. The main purpose doctrine is primary object and an economic benefit to surety. The promise is not within the statute, and the promise made to a debtor is not included in that suretyship provision. Other contracts are executor administrator provisions. Applies to promises to answer personally for duties and decedents. Marriage provisions also apply to this. Applies to promises made in consideration of marriage, but not to mutual promises to marry. Land contract provisions apply in the transfer of right, privileges, powers, or immunities in real property. Then we have some of the other provisions. The 1 year provision applies to contracts that cannot be performed within a year. So with these, we think to longer term when it gets to the statute of frauds. These are normally longer term propositions. So anything that takes more than a year, we're going to need a written instrument to show that it is in place. There can be many reasons that you want to do this, no matter if there was a statute of frauds or not. Places of business change over their management, and sometimes they change hands. If you have a contract with someone, you may want to have some way to show new ownership. Hey, this is a contract I had that was existing, and it's covered by the statute of frauds to make it, a contract that is legal for this extended period of time to try to get them to go along with it. Or if management changes and there may not be someone to, let them know, hey, you're still under contract with this for this amount of time. So these things are, they're in place to protect all those that are parties to a contract. The statute of frauds in and of itself is designed to protect the parties to make sure that everyone is doing what they should. And there's a statute involved in backing it up. In other contracts, you have just the agreement between the two people that or the two parties that is signed or not signed. It could be an express, or it could be an implied contract. Once we get into the statute of frauds, we now have a written instrument that is statutorily designed to ensure that contracts are being done in a proper way. Now, it doesn't bring criminal issues unless there is a blatant form of fraud that is being performed or being conducted. Then it could end up in criminal penalties. But for the most part, it still falls back to that making everyone whole that is a party to the contract. The possibility test is a criterion, whether it's possible or not, likely for the agreement to be performed within a year. So you look at that ahead of time. Is it possible for this to happen prior to the end of a year? If not, we're going to trigger that 1 year provision. The computation of time runs from the time that the agreement is made. Once we agree on this, then we start that timer to count if we're going to make a year or not. Full performance by one party makes the promise of the other party enforceable under majority view when it comes to this. So most of the time it's going to be seen in that way. And the sale of goods, as far as the contract for other statute of frauds, is the sale of goods is a contract for the price of $500 or more. It must be evidenced in writing or record to be enforceable. If it's over that amount and you do not have it, it's not necessarily an enforceable contract. The statute of frauds is all about that enforceability. Kind of alluded to that a couple of slides ago. It's all about the ability for the parties to enforce the contract on the other party. So we entered into this contract. We have all these stipulations, and now we have some statutory backbone as far as how we can force the other party to meet the terms of the contract that they have agreed to. And we want to make sure that there is some way we can enforce that. The courts use it to enforce this the same way as they would promissory estoppel with other contracts. We want to make sure that these contracts are being enforced. You don't necessarily need promissory estoppel with this because we're going to have a written instrument that lines out what the contract is going to be. So we're not looking for reliance upon a promise in previous history. We're looking at reliance on that written instrument that all parties have agreed to. And no matter how they agree to it, there's some way they signify they agreed to it, some form of signature, some form of proof that they agreed to this. And so now we have some enforceability behind that. So if we have to go to court to get a contract enforced and for a contract to be completed, then we can show, hey, this is what we have. This is where the contract stipulates what's going to be done, the X, Y, and Z of it. And this is what we want to move forward with. We want to make sure that we're being made whole or the contract's being completed, whatever the case may be. Specially manufactured goods or oral contract for specially manufactured goods is enforceable. Delivery or payment and acceptance validates the contract only for the goods that have been accepted or for which payment has been accepted. Now, keep in mind, sometimes payment is per item. So if you have a contract where you have purchased goods from a supplier and you're paying once those goods are delivered, so you have a contract that each month they'll deliver 15 cases of a item that you've purchased that you may be reselling or using for your business, and you only pay upon the delivery of those, you can't enforce the other delivery, if they say 1 month they can't, you don't have quite as much to enforce it because it's based upon delivery and then the purchase. You haven't paid for it, so there's at this point all parties are even. So we do not have anything stipulating that. Now you do have a breach that you could go after, but all parties are even. So the statute of frauds states that it validates the contract only for goods that have been accepted or for which payment has been, or goods that have been accepted or payment has been accepted. So the exchange happens on that monthly time frame, and so you may have to go through other steps if it needs to be enforced. If you pay in advance, then the expectation of each month them delivering those 15 would be something that you can say, okay, under the statute of frauds, we have this agreement. I've paid you in advance, and now I need the other, if it's been 4 months or 4 months left and they're saying they can't do it and you've already paid for that 4 months, I either need my money back or I need those other 60 cases to complete this order. I'll let you go over these charts. The modification or rescission of contracts in the statute of frauds, oral contracts modifying existing contracts are unenforceable if the resulting contract is within the statute of frauds. Your general provisions for these, the writing or record must specify the parties to the contract. All right, so we need to know who is the offerer, who is the offeree, all right, who's going to be sending this out, who's accepting it. The subject matter and essential terms. Essential terms are price. It can be delivery instructions, address of the parties, and name of the parties. Of course, we already have to specify the parties' contract, but we need to know their addresses. We need to know what's being delivered, how it's being delivered, the amount, everything that goes into the specifics of the items and what's being exchanged for those items, and then signed by the party to be charged or by their agent. All right, so the one that is going to be receiving the items is paying, they sign, and you have everything in place. If you ever noticed on a sales contract for the purchase of a vehicle, things on those lines, you're signing a lot of paperwork, nobody else is signing because it's implied that they're making the offer, their signature is in place. You're signing to signify that you agree to the terms. The writing. Okay, now the writing or record must be sufficient to indicate that a contract has been made between the parties. It's signed by the party against whom enforcement assault or their authorized agent, and it specifies a quantity of goods to be sold. So if you're trying to enforce it, if they did not sign it, then your enforcement would not be as easy for you to prove if they did not sign, because that your agreement in this type is that signature, whether it's an electronic signature or the signature of a company that is, necessarily a loan would not be covered in this, because in most car purchases, that loan is going through a agency of some sort. But in cases of you buying from a vendor, you have a party who needs to sign that this is what they're going to deliver so that you can enforce it. Written confirmation between merchants is sufficient against the sender, is also sufficient against the recipient, unless the recipient gives written notice of their rejection within 10 days. You have time frames that work within the statute of frauds that are not necessarily in place in other contracts also. An oral contract under it is not enforceable. Full performance statute does not apply to executed contracts. And then restitution is available in a quasi contract, similar to what we talked about with the others, in benefits conferred and reliance on the oral contract. Promissory estoppel can kick in for oral contracts if there's a need for them to be enforced. And then parole evidence. So we talked about promissory estoppel, so I didn't spend a lot of time on it. I want to talk about parole evidence. This is what's really new as far as this. The other parts were enforceability additions to what contracts already were. Parole evidence is when there may be a time where something needs to be changed. So when the parties express a contract in writing that they intend to be the complete and final expression of their rights and duties, evidence of their prior oral written negotiations or agreements of their contemporaneous oral agreements that vary or change the written contract are not admissible. So if there was talk prior to what the contract was designed to do, uh, we're basing what we're enforcing on the contract that is in place, not negotiations prior, not any negotiations going on. It's that type of stuff, right? That's parole evidence. When the parole evidence rule does not apply, is if the contract is not an integrated document or if there's a correction to a typographical error. Any type of error along those lines can be fixed, uh, showing that a contract is void or voidable. Whether a condition has in fact occurred that triggers the statute of frauds, and showing a subsequent mutual rescission or modification of the contract. The parties agree in mutual agreement to rescind the contract or modify the contract, but not one party wanting to add to or subtract from the contract works. Supplemental evidence that can be put into place is normal course of dealing. All right, so normal course of dealing was similar to the customs and usage that we talked about in the previous video. This one is the previous conduct between the parties. What have they done prior? So promissory estoppel, I talked about, relies sometimes on history of the parties. The parole evidence rule relies upon that too. So what was their previous conduct? Have they allowed or given way for contracts to be modified and stuff? If that's something they did, okay. And then uses of trade is if there's a practice engaged in a trade or industry that is a common practice in that trade, that could be something that could possibly change the contract in that way. Course of performance can be admitted. Conduct between the parties concerning performance of the particular contract, and then any type of supplemental consistent evidence that shows that there needs to be a change can be admitted to prove that it needs to be done. The parole evidence rule, when we look at it, is if we have a written contract, an integrated contract, evidence, those type of things. So if we have those, a written contract, then the parole evidence rule applies. You cannot put any other evidence in. It's not admissible. If you do not have one, then the parole evidence rule does not apply, and evidence to the contrary of the existing contract can be admissible. So the evidence as to the contrary of what was there, or evidence of a change that is needing to be made or was agreed upon prior to the signature that may not have been included in the contract, those type of things. So there's a list here that goes through different conditions or different possibilities, and they're either a yes or no. Any of these evidence that varies the contract, if that's in there, then the parole evidence rule does not applies, and you can't change anything. Evidence prior or contemporaneous, we talked about that. That will not allow it to change. But evidence that proves fraud, misrepresentation, undue influence, mistake, duress, incapacity, illegality, or unconscionability. If that is present, then the parole evidence rule does not apply, and that contract can be viewed no matter if there was signatures on it, if partial completion of it is not, if for whatever reason, if those things can be shown, then we look at that contract and decide if that contract is something that should be voided. Things like undue influence, misrepresentation, of course, fraud, an illegal aspect of the contract that pops up, incapacity by one of the parties, if it's shown there was duress there, or unconscionability, which is a person of normal thinking, normal mind would not enter into that contract if they were able to make a clear decision at the time. It's not the same as duress, it's a little different. But if they're not able to make a decision, based upon what a normal person or a reasonable person with a clear conscience would be able to make, then the rule does not apply, and then you can look at that. Evidence of a condition precedent, or evidence that explains an ambiguity, or evidence of a clerical record. Evidence that explains an ambiguity. Once again, if you make sure your contract is clear in what it says, there is Nothing that is too specific to only a certain type of industry. If there's not a place for it, then you can avoid that ambiguity. So that's something that's real good to avoid as much as possible in a contract, is ambiguity, because that allows the courts to look at things and decide, okay, well, maybe this is not exactly what they meant, when you're not really changing the meaning of it in your eyes, but the courts may not see it the same. And so the courts may decide that they need to change in some way. So we go now to the interpretation of contracts and how they're set up. The ascertainment of the meaning of a promise or an agreement or a term of the promise or agreement is how you interpret a contract. The rules for that are words and conduct are interpreted in light of all circumstances, and the principal purpose is given great weight. So the principal purpose of the words or conduct within the contract is what's given the most weight. A writing is interpreted as a whole, and all writings that are part of the same transaction are interpreted together. So there's not pieces of this that gets interpreted one way based upon this precedent, or this piece over here based upon this normal course of action or normal course of trade. It all gets put in together. If you have ambiguity in some way that doesn't align with this, or over here, that's going to be where you're going to run into problems. So once again, being clear. Words and conduct are interpreted in light of all circumstances. Be clear in the words you use. The list of actions that need to be taken. Being clear in that you can't stress that enough, to be clear in your contracts and when you're writing these, to make sure that it is easy to be understood when it goes to the courts. The lawyers, the judges, are experts in the law. They may not be experts in the industry for which the contract is written for, which then leads to them having to interpret what they're reading. The clearer you can have it, the less specific terms you can have in there that apply to an industry that may even be something different in another industry. You want to make sure that those are, really clear in how they're explained. Don't use jargon that only someone in the industry would understand. There are certain words you could say if you're in construction. There are certain things you could talk about that only someone else in construction would understand. Same way in the medical field, that there are certain terms that can be used in the medical field that another person would just look at you and say, okay, now the explanation, please. When that happens, it causes issues within contracts if that contract has to be presented to the courts for some type of ruling. So making sure you do not have that and that they're clear allows for them to be interpreted in the proper way instead of with mistakes in translation, is the best way to put that. So make sure that you're being clear. Language that has a commonly accepted meaning is interpreted in accordance with that meaning. Once again, the likelihood that your industry would have specific language that may have another meaning in general language is going to go based upon that commonly accepted meaning, not the specific to your industry. And technical terms or words of art are given their technical meaning. So if there's a technical term that you have to use in there, then you have to make sure that it's clear that what that meaning is going to be. The manifestation of intention of the parties is interpreted as consistent with each other and with any relevant course of performance, course of dealing, or uses of trade, once again. An interpretation that gives a reasonable, lawful, effective meaning to all the terms is preferred over interpretation that leaves the part unreasonable, lawful, or to no effect. An interpretation that gives a reasonable, lawful, and effective meaning to all terms. All right. Specific terms and exact terms are given greater weight than general language. Separately negotiated or added terms are given greater weight than standardized terms or other terms not separately negotiated. Express terms, course of performance, course of dealing, uses of trade are weighted in that order. And where a term or promise has several possible meanings, it will be interpreted against the party who supplied the contract or the term. Make sure that if you're the person who is being sent the contract to accept it, that you understand everything in it also. Do not sign it if you do not accept it, or at least get somebody to tell you what you're looking at and explain that to you. Where written provisions are inconsistent with typed or printed provisions, the written provision is given preference. That would have been the original part before it's printed out or typed. Likewise, typed provisions are given preference over printed. Why is this? Because before something is sent to be printed, uh, at some point, ideas were written down. Contract was probably written out for somebody else to type. So that's the second person. And then once it's printed, it becomes just the result of maybe different hands touching it. So that original form, whatever the original form was, is what they're going to look at to give it preference over the others. The amount payable is set forth in both figures and words, and the amounts differ. The words control the figures. So if you have 500,000 written as 500, comma 000, and then you have the words 500,000 written out. If for some reason 500,000 is the figure that you're looking for, it is the amount you're looking for. But for some reason, when it was being typed up, it reads 500,001 for whatever reason. Or we'll even go 500,009 with a zero being next to the nine on the top of a keyboard. If that is the case, as long as it is written out in words, $500,000, that will be what the number is that you use, because it's written that way and it takes precedent over word or numbers that are typed in. All right, so that one was real quick. Statute of frauds it just adds to what you've already learned. The parole evidence is the big part of that. What can be changed, how it can be changed, what cannot be changed. Stop the share so it gets bigger here. But that is the where you're looking at and what is important there. Key terms here are key things to remember. If it takes more than a year for it to be completed, it needs to be in writing. If it's more than $500 in value, it needs to be in writing also. Those are when you look at the statute of frauds for most states, those are your two big pieces that it's looking at. There are other statutes that cover the pieces that we talked about. Under the UCC, it all gets tied into one big list, but normally with the state statutes, it's going to be in pieces. But keep those in mind. And the parole evidence rule is that changes are not easily made once it's in writing. You're going to have to pass some tests, basically, to get to the point where you can change it. They're going to look at a lot of different things and see what is going on. To get some real good clarity on it, when you open up the PowerPoint, click on that link for the UCC. I'll share that link also in the course so you can have it to look at. It is helpful to kind of view that. Questions will come designed based on the UCC itself, so you may want to see it. I believe in the back of the book, I know in the written version, in the back of the book, there is a connection to UCC Article 2 and the statute of frauds and those type of things. I'm pretty sure it's going to be that way in the electronic book also. All right, so last two videos, the one before this one and this one, that's contracts. Good overview of them. We're not spending an excessive amount of time on contracts this term, as opposed to what I've done prior. I wanted to add in some stuff that y'all had asked for, or students prior to you had asked for in other classes that they thought would be interesting. So that gives us some extra time by shrinking down this section. I hope it covers it enough to understand it. Please read through it, get a good understanding of it. And there's a lot of information on contracts. It's not always a good idea to rely on the forms that you can find online, because sometimes they do have a lot of ambiguity in them because they're designed to cover a bunch of different terms. So make sure that you're not relying so much on those. And other than that, if you have any questions, please reach out. I said in the previous video, I'll reiterate it in this one, that by the time before the weekend's over, your midterms and case study 3 will be graded. case study form going to move out a week, the due date on it. I want you to have plenty of time to look over the feedback from the 3 case studies. Also, there are a few that are missing case studies. Your grades show it. If you have missed 1 case study out of the 2 that have been graded, or the 3, you're likely somewhere in a high F to a low C, depending on how you've done on other stuff, maybe even a mid-range D. So if you're trying to get your grade up, these case studies are imperative that you do that, especially if you're losing points on the ones you have submitted. So reach out to me and let's work on trying to get some points somehow for the case studies that were missed, maybe turn them in a little later and get some points on that. Other than that, y'all stay safe and study hard.